All right, welcome everybody. We're going to wait just a few more minutes to make sure that everyone gets joined, and then we'll get started. Well, we'll go ahead and get started. I think people will continue to file in, but we've got a critical mass, so we'll get going. Good morning. Welcome to the Burr Morning Show. I'm Brant Smithini, and I appreciate all of you who have decided to join me this morning. We had a great response to this topic, so I'm looking forward to it. I think there's some interesting things that have happened recently that will be important to discuss, and I hope that I can help get all of us up to speed on what we need to know. It's Friday. It's 1,000,000 degrees in Birmingham, and probably where you are too. And I'm flying solo. I don't have to share the spotlight today, so there's no telling what sort of trouble we might get into. I'm going to do the best I can throughout this presentation to keep my political opinions to myself and just give you guys some useful info on what the Supreme Court has been doing recently that might impact private employers. As always, we welcome your questions. Please type those into the Q&A feature. I will check those as we go, hopefully, but for sure, I'll do my best to answer them at the end. My plan is to leave some time to hit those if we have them, and I think we will today. We're going to get through this relatively quickly. There are about 5 cases that I want to discuss and go through with you. But that probably won't take too long, and then we should have some time for some questions if you guys have them. So feel free to stick those in the Q&A, and we'll address those at the end. The Supreme Court's been busy. In most terms, the decisions that the court releases are either fairly muted or else they were so widely predicted that we'd already kind of baked in the outcome. We'd begun, usually to advise clients based on what we expected the Supreme Court to do. But this term was a little bit different. In at least 3 of these cases, I'd suggest most of us, lawyers included, didn't see coming exactly what happened. And, we're not going to talk about anything today that's going to require you to schedule a special board of directors meeting or, anything quite that extreme. But what I am going to do is give you some things to think about, decide how to apply them within the context of your unique workplace. Unlike most of the presentations that we do with these morning shows, this isn't a topic with a theme that flows from one slide to the next. Our agenda today is basically 5 completely distinct issues. And I'm going to hit them one at a time, and we'll spend a few minutes on each one, and then we'll move on to the next. 2 of these cases, the first 2 listed here on this slide, are specific. They will directly impact employers, and the other 3 that we're going to talk about probably don't directly impact employers in the same way, but there's a real genuine suspicion that they might, or at least that they reflect a direction that we're headed that might lead to an impact on private employers. The first thing we're going to do today is get a little FLSA refresher, a Fair Labor Standards Act update. And this Hewitt case mainly serves as a tool to highlight an issue that employers all too often overlook. So we'll talk about the FLSA. Next, the Groff case is probably the one case on this list that might immediately change how you do things. It's the sort of issue that HR professionals need to learn, need to understand. But it's also not likely the sort of thing that you would ever train, because probably you don't want your frontline supervisors making the kinds of decisions that are required when it comes to religious accommodations in the workplace. And then we're going to get into the two most controversial and, frankly, confusing cases of the term. Both of those deal with constitutional issues, the First Amendment and the 14th Amendment. And we're going to explore how those decisions might impact private employers in ways that probably are not intended, but are inevitable. Finally, we're going to talk about really a pure procedural issue that frankly could change your exposure analysis all by itself. And it's rare that procedural issues have that sort of impact, but this is one that really could. Where you get sued might make the difference between, whether you barely think about the case, you just let your lawyers handle it and you're not worried about it, or whether it wakes you up in the middle of the night in a cold sweat. That the location of the lawsuit really can have that sort of impact. It might be to you the most boring case on the agenda today, but to me, it's really interesting. It's surprising new law. It caught a lot of us off guard. And I think once we discuss that case, you're probably gonna feel the same way, interested enough to be worried about the impact that it might have on you. So let's just jump right in. It's relatively rare for Fair Labor Standards Act cases to find their way to the Supreme Court on issues like exemptions. We've wished that they would over the years. A lot of us would love to have some clarification on the duties test, for example, or some of the other nuances of things like collective actions, how the certification process works, things like that. But this case did make it to the Supreme Court and on an interesting issue. As a reminder, the three most common white-collar exemptions that exist under the Fair Labor Standards Act are the executive, the administrative, and the professional. The Hewitt case deals with the executive exemption, but its analysis really can apply to all three. Hewitt, the plaintiff, worked on an oil rig, and he worked as many as 84 hours per week when he was on duty. Helix treated Hewitt as an exempt under the executive exemption, but he was paid a day rate with no overtime compensation. And he made, because he was working on an oil rig 84 hours a week, as much as $200,000 a year in his role, even working on a day rate. So Helix argued that because Hewitt was also a, quote, highly compensated employee, he satisfied the salary basis test, even though he was paid on a day rate basis. And a lot of you can probably predict where we're headed with this. The court relied on the fact that Hewitt didn't receive the full salary that he was theoretically guaranteed for every work week without regard to the number of days or hours he works. So obviously, a day rate employee is not paid with regard to how many days he works. He's only paid for the days he actually works. So to the court, and now to all of us, because the court says so, it didn't matter that he always received more than $455 per week, the minimum salary threshold, because the stream of pay was not steady and predictable, no matter how much it was. With the court saying, because the payment that Hewitt received was not guaranteed every week, no matter what, because it was a day rate, that there was no steadiness, there was no predictability to the compensation. Therefore, it didn't satisfy the minimum salary threshold, because that requires a guaranteed minimum salary on a weekly basis. It also mattered to the court that there was another regulation that deals with daily pay. So there's a day rate regulation, and the court relied on the interpretation of that to sort of inform how it dealt with this particular issue. Helix had tried to argue that the rule is different for highly compensated employees. And in fact, there is a rule that addresses an exemption for highly compensated employees. Court said, because there's a day rate regulation as well, it trumps essentially the highly compensated employee exemption. So the court rejected Helix's theory and held that a scheme, and this is what's important, I think, for us, A pay scheme that guarantees neither a true salary nor overtime is unlawful. So most of you probably don't have day rate employees who make six figures. That's a pretty unique business model. You know, we're talking about oil workers. We're talking about, you know, for example, I've got a client that pays employees historically what we'll call day rates in catastrophic events where they were adjusting catastrophic events. And so, you know, there's some context where this is a little bit more prevalent, but most of us don't pay people this way. But it still provides useful guidance to us, even if it's only for this reason. It serves as an important reminder about what we already know, but sometimes forget. And that is, if we pay someone on a salary basis, all three parts of the test to determine the exempt status must be met, and we can't take, you know, really any individual element for granted. You've heard us talk for years about the duties test and how important it is to conduct regular audits to make sure that what we believe, you know, HR professionals who have created job descriptions, you know, written down what our expectations are for the role, what we believe our employees do all day is actually what they do, right? I mean, that's one of the fundamental problems that we have in, you know, as HR professionals, as in-house counsel, you know, that we think a thing is working the way that we said it should work or that we were told it would work. And so we classify employees as exempt on that assumption. And then an audit reveals that, hey, actually, that position has evolved and that's not what they do anymore. So here, for example, in this Hewitt case, it's critical that an employee, you know, regularly makes recommendations about whether to hire and fire employees that are given weight. You've also heard us talk about the minimum salary threshold and the fact that it might increase. We've talked about this in prior morning shows, if you've attended those, the fact that the minimum salary threshold is under review right now, and we anticipate regulations to increase that threshold. So we've got the duties test and we've got the minimum salary threshold. But the third lesson here is the one that this case deals with and the one that sometimes employers forget, overlook, particularly employers who don't have sophisticated HR or in-house counsel. Happens a lot. And that is, a true salary is not met just because we pay an employee a lot of money. Just because we exceed the minimum salary threshold and what we pay the employee doesn't mean that they receive a true salary under the meaning of the Fair Labor Standards Act. We can't make deductions from salaries for absences or partial weeks without a risk that we've destroyed the exemption. Helix had a scheme that it thought was compliant because the employee who didn't get paid for a day, if he didn't work that day, still made more than the highly compensated threshold. So it just assumed that because it met that highly compensated threshold and how much it was paying the employee, it didn't matter that some days when the employee didn't work during the work week, he didn't get paid for that day that he didn't work during the work week. But what's more common for us, for the average employer, is to simply not remember that exempt and salary don't necessarily mean the same thing. And I run into this a lot with my clients who, will dock an employee when they're absent, that won't charge it to PTO, that will just simply reduce the amount that they pay the employee for the work week. And in any instance where we do that, it's going to run a risk that we've destroyed the exemption for that employee and actually all of the employees that work in that job class or category for the employer. So we got to push back when that occurs, and we've got to pay attention to it. This often happens because there are people who are making the decisions about payroll on a regular basis that just that's their job, but they're not trained or sophisticated in the Fair Labor Standards Act like we might be or like we would want them to be, who don't understand that there's a problem with reducing an employee's compensation, proportional to the amount of time that they work during the week. It seems logical, right? I mean, if you only work 4 days, you should only get paid for 4 days. That's not the way it works with our exempt employees who have to receive the minimum salary threshold. They have to be guaranteed a minimum salary on a weekly basis to meet an exemption from overtime obligations. You know, what's important really more than anything else is to pay attention to this issue because the exposure can be enormous. It probably won't be as enormous for most of us as it is for Helix Energy Solutions in this case, because they're dealing with an employee who's making a couple $100,000 a year and is now entitled to overtime for, if the guy's working 84 hours a week, for 44 hours per week of overtime. That's probably more than the base salary that he earned in the first place, that they now owe him in back wages for the period that he worked, for which he was not receiving the guaranteed minimum salary according to the Supreme Court. While that's an extreme example of exposure that we face, the exposure is real for all of us. If we've got employees that are paid on a salary basis and we treat them as exempt, well, number one, we usually don't track their hours, right? That's not standard practice for most employers to track the hours of somebody who is paid, as an exempt employee on a salary basis. So we've got that risk. The hours that they may claim in litigation would be unpredictable and probably higher than realistic. Number two, we've got, generally speaking, higher hourly rates that we're dealing with these employees. If they're exempt, they're paid, they're paid on a salary basis. So we pay them more than we might pay our hourly employees. So when they become entitled to overtime, it's a bigger number. And it's a bigger number that could potentially have a ripple effect throughout the organization if there are other employees in that job class or category. So again, it's just a case that we want to recognize the lessons from, even though the facts don't necessarily apply to a lot of employers in a very specific way, the message does. And it's one that we want to really pay attention to and think about when we're evaluating exempt employees, when we're talking to our payroll staff, and we're talking to our frontline supervisors who might send a message to payroll. Hey, John didn't come to work on Thursday. Make sure he doesn't get paid for Thursday. We've got to know that, if they're exempt, we've got to pay them for every day that they work to ensure that they're guaranteed the minimum salary that the FLSA requires. The next case that directly impacts employers deals with the complex concept of accommodation. Most of us are far more familiar with accommodations under the ADA, the Americans with Disabilities Act. And we only rarely see requests for religious accommodation. I know that in my career, I bet that the number of ADA accommodation requests outnumbers religious accommodation requests 100 to 1. In the calls that I've received from clients and the issues that I've dealt with. This case may change that to some extent because it expands the obligations on employers. And it's important to know that this was a unanimous court that issued this opinion. I'm going to explain in a minute why it was unanimous. It's sort of a unique reason, but it was unanimous. And so we have to understand that the Supreme Court overwhelmingly ruled the way that it did. It wasn't a close call. So to tell you a little bit about the case, Groff is an evangelical Christian who believes that Sundays should be devoted only to worship and rest. When the U.S. Postal Service, where he worked, he was a postal service carrier. When it began to facilitate deliveries for Amazon, the USPS began to require Sunday work. And at first, Groff transferred to a route that didn't make Sunday deliveries. But as Amazon began to further, take over the world, I guess. I mean, that seems to be what, where everybody's deliveries come from now. They began at the new station that Groff had transferred to. It was more of a rural route that Amazon didn't service, but they service everything now. So the route that he transferred to then began to also make Amazon deliveries, and they also required Sunday work. So Groff refused still to work on Sundays. And the USPS redistributed his Sunday deliveries to other employees at first. But it also began at the same time to progressively discipline him for absences when he was required to work on Sunday and refused. And eventually he resigned. He sued the USPS and claimed that it could have accommodated him in his Sunday religious belief without an undue hardship on its business. Both of the lower courts agreed with the Postal Service that an employer shouldn't be required to bear more than a de minimis cost to provide a religious accommodation. And de minimis, of course, you've heard this term. It just means, the very minimum, right? Something that is trivial, something that is almost insignificant. And that had been the way most employers had evaluated religious accommodations, up until this case. And that is, if this really creates any sort of burden on us at all, we don't have to do it. And so it has really limited the opportunities to request religious accommodations as a practical matter in the workplace. The lower courts found that because the exemption from Sunday work imposed on his coworkers and it disrupted the workflow, that was sufficient to deny the request. That's all it took, was an imposition on coworkers and a disruption to the workflow. And the lower court said that was sufficient to deny the request for accommodation. The Supreme Court disagreed, and it said the employer bears the burden. And this is significant because it is putting the burden on the employer to show that granting the accommodation would result in, quote, substantial increased costs. It's not the employee's burden to show that it wouldn't, which is, how a lot of us have perceived this shifting of burdens to work. Historically, we have required the employee to show why this would work, why this, wasn't gonna increase our costs. We can just say that it will, and that was sufficient. And the Supreme Court is concluding that undue hardship, the term undue hardship is prevalent in this accommodation analysis, both under the ADA, religious accommodations. It concluded that the undue hardship is only shown when a burden is substantial in the overall context of an employer's business. We're going to talk a little bit about what that means, but substantial in the overall context of an employer's business. And that sounds like a pretty steep burden, right? The court notes in its opinion that the EEOC's construction of the existing law is pretty much correct, and that likely it's not going to be affected too much. I don't know if that's true or not, but it gives me some hope that if we've been following the EEOC guidelines, the Supreme Court is going to say, all right, yeah, that's what we're talking about here. We're talking about the way that the EEOC has analyzed this. But it stops short of saying that the EEOC's interpretation is going to be exactly right. And it even notes that in its opinion that there may be instances where the guidelines that the EEOC uses for religious accommodation analysis is not sufficient. And what it says is that it prefers to let the courts sort out what substantial and undue hardship actually means, which is great because there's nothing more, I'm sure you would agree with me, that's more fun for an employer than to be a test case, to not have any idea what the outcome is going to be. And, we're going to be the guinea pig for that decision. And the court also refuses to adopt existing case law from the ADA. That's what a lot of us would have assumed courts would do in analyzing religious accommodation, would just simply use the ADA analysis from existing case law. And the court says, that's not necessarily how we're going to interpret religious accommodation requests because there are different interests at play between a religious accommodation and a disability accommodation. So ultimately, the problem with this case and the thing that is most troubling for employers is that it fails intentionally, didn't just overlook it. They intentionally fail to tell employers exactly what it means. And instead, they note that the that the analysis is always going to be case by case. Always fun to hear those terms case by case and know somebody might be second guessing us down the line. You know, in other words, go on, do what you do, and after you've done it, we'll tell you if it was right or not. That's always a fun place to be. The Supreme Court did at least provide a few clarifying points here. First, an employer can't say a hardship is undue just because it impacts a coworker. And, you know, that was the issue in this case. That's what the lower courts relied on, the imposition on coworkers. And I can tell you that in a lot of the analyses that I've done over the years, what the employer has told me, and I have said is fine, is denying the request because it's going to require coworkers to bear a greater burden, to work more hours, to have a more substantial obligation based on this request that the employee is making. The court is not saying that it can never, you can never use imposition on a coworker as the basis for your denial, but it's saying, you know, just because it impacts a coworker is insufficient. So if, for example, you know, Mary has to work on Sunday because John's got a religious belief that prevents him from working on Sunday. The fact that Mary doesn't want to is not going to be sufficient. It's the question that now we have to ask ourselves and answer is whether we have to now pay Mary overtime, for example, when we'd have only paid John straight time. And whether that cost is substantial, according to the Supreme Court, and whether other options like shift swapping could be considered. And that the court seemed to think that that was really critical. We have to consider other options. We can't just say no. We have to evaluate whether there are some other things that we can do to make this accommodation work, despite, you know, whatever imposition it might create on coworkers or the employer, costs, those kind of things. Second thing the court did to clarify was to say that we can't deny a request based on undue hardship just because other employees don't like the religious practice. And, you know, that's a thing that I've certainly heard over the years is, you know, that there's some unusual, unique, controversial religious belief that an employee has that other employees don't like, and that can create tension and disruption in the workplace. And so, you know, when the accommodations requested, if it imposes any sort of burden on a coworker, there's resistance to it, and, you know, employers arguing that, okay, well, that in itself is more than de minimis, and so we deny the request for accommodation. And the court's saying, you know, that's not going to get it done. It doesn't matter whether someone else has a problem with or feels themselves burdened or offended by the religious accommodation request. It's really just this, whether it creates a substantial cost on the employer. So, you know, we've got to bear that in mind as we go through our religious accommodation analysis. And then finally, process is key. You know, we can't merely just say the request is unreasonable. And, you know, we would have never encouraged or advised the clients to do that anyway. I hope that all of you would not have ignored the process, but the process is now going to be really even more relevant. It's shown to have been the key to the whole thing. We've got to consider other options to reasonably accommodate. And like with the ADA, it's obvious that the documentation of the process itself and all the various options that were considered and rejected, and, you know, the reasons why, those are going to be the best and only ways to defend a denial of a reasonable accommodation for a religious belief. So, you know, the process has always been important. The documentation of that process, I have always believed, frankly, because it's never really been proven wrong to me, that if an employer genuinely and seriously engages in an interactive process, considers the employee's request, and makes a reasoned and informed decision that it can't accommodate, documents that reason. I've never seen an employer have a problem with that. It is the interactive process itself that the courts are going to be looking to ensure basically that the employee got a fair hearing, that there was a request, it was considered, and the reasons were the employer's reasons. And as long as they're arguably legitimate, most courts are gonna support them. Now, here, because we're introducing the element of religion into this analysis, there's going to be a little bit more scrutiny, I think. And we've got to be a little bit more cautious, especially now that we see that the Supreme Court is so serious about these issues. And that leads me into the reason for the unanimous decision. That should be obvious, I think, to us all. The conservative wing of the court wanted to emphasize this trend towards religious rights in the workplace, and that's going to be highlighted in this next case we're going to talk about. The liberal wing of the court wanted to take advantage of this to increase worker protections, to expand what the accommodation analysis looks like. And so, I'm sure that wing of the court anticipates that this decision is going to bleed into ADA accommodation analysis, because it will. And so there's also the new Pregnant Worker Fairness Act that is going to involve accommodation analysis with pregnant employees who are not necessarily disabled. They are simply pregnant, and they are entitled to accommodations for that pregnancy under this new law. All of this analysis is going to be relevant when we talk about these other places where accommodations are offered. And so, the liberal wing of the court expanded the definition. The conservative wing, treated it the way it did because of the religious element to it. And for what that means for all of us is that we just need to be alert to the evolution of these laws. The courts found common ground here. This is an area where workers' rights are going to be protected. And so we need to recognize that this is an issue that we're going to pay particular attention to, be cautious with, and most importantly, create a record, document, make sure that you engage in the process, you write it down, you explain your reasons, you're able to justify those reasons to a court if you're required. So I mentioned the next case has similar elements. This is the first one that doesn't directly impact workers, but it's something that we believe is relevant and for all of us to think about, because we think these issues are going to bleed into the way private employers manage the workforce. So free speech, as a fundamental right, it's often misunderstood. And you've probably heard lawyers like me explain that the First Amendment only applies to government action. And of course, that's true. And you have the freedom to speak about whatever you want with whatever words you prefer. The government can't make that illegal. But your employer can tell you what you can't say at work. There's obviously some nuances to that we're not going to get into today. But the critical issue for us right now is this recent highly publicized case about the kind of agitation between anti-discrimination laws on the one hand and anti-discrimination laws that would make things like discrimination based on sexual orientation illegal. And then some people's position that I shouldn't have to provide services to people engaged in an activity like getting married that's inconsistent with my personal beliefs. And so that's the agitation between those two elements. In this particular case, Colorado had a law that stated a place that held itself out as providing services to the public can't deny full and equal enjoyment of its goods and services based on a protected characteristic, like in this case, sexual orientation. Elena's said she wanted to create websites for couples that were getting married, but not couples who are the same sex, because that conflicts with her religious beliefs about marriage. After both lower courts ruled against her, and again, this is a case where both lower courts ruled in one manner and the Supreme Court reversed them. The Supreme Court held that anti-discrimination laws are not themselves immune from the demands of the Constitution. And the court emphasized that this case was about expression and not public accommodations. And that's a really critical distinction here, is that the plaintiff was arguing that she was expressing herself with her creativity in creating these websites. And the court emphasizes that. It relied heavily on stipulated facts from the parties that clarified that this is a case about expression and not public accommodation. So what does that mean? Well, it still means that we can't, a business can't deny its service, for example, to someone that comes into a restaurant to eat based on things like sexual orientation or race or gender or, the protected characteristics. But the implications of this should be pretty obvious to us. If the Supreme Court's going to hold a state law unconstitutional because a business might have to provide a particular service with which it disagrees, you have to ask where that analysis ends. Are DEI initiatives that employers require employees to adhere to and participate in also not immune from the demands of the Constitution if made in an effort to comply with state anti-discrimination laws? So, what if an employee doesn't believe he or she should have to work with a transgender employee, but based on a religious belief? The court has not indicated that it's ever going to go that far necessarily, but it also hasn't indicated that it won't. And it's at least signaled that it's going to find freedom of expression to outweigh state laws that restrict speech in different contexts. Refuse to work with a coworker because of a religious belief, that's based on gender, race, sexual orientation. An employee can't say, I'm not going to work with that person, and we have to tolerate that. And an employee can't refuse, for example, to serve a customer if the employer requires that employees provide that consistent service to everyone. So, the court's not going that far at the moment. And we still, as employers, have the obligation, I guess the right and the obligation to implement our DEI initiatives, to expand the workforce where we think it's appropriate through outreach, things like that. And we're going to talk about affirmative action in a second. But all of these issues appear to be fluid and worthy of your attention. These are the sort of things that we need to pay attention to, both the lawyers that practice in this area, in-house counsel, the impact that it might have on your workforce, and HR on the front lines dealing with employees who are hearing these things maybe. And that's one of the things that we talk about a lot. The access to information is just so different than it was 20, 25 years ago. And employees just know a lot more than they used to, but they also often misunderstand what they think they know. This notion that there is now free speech at work is going to bleed into your workplace. Employees are going to believe, based on things that they read, blurbs and snippets from, that they don't have to work with or service or deal with customers who are a particular, have a particular sexual orientation or might be transgender because they think they have free speech based on their religious beliefs at work. So we've got to balance those things. We've got to pay attention to them. We've got to make sure we know what our rights are so that we can continue to enforce our policies and procedures, because that's going to be important as we move forward, to have these consistent policies and procedures that are enforced and that we let our employees know these are our rules and these are what we require you. This is what the behavior that we require, notwithstanding this, Elena's case that as of now is limited to, this particular narrow issue of the state attempting to enforce a law dealing with freedom of expression versus private employers, public accommodations, the ordinary workplace. And so we just need to pay attention to those things. So similarly, the very controversial decision on affirmative action in college admissions is instructive for, I believe, what it says about the climate more than the actual words in the court's opinion. So here, a 6-justice majority, so a 6-3, 6-justice majority ruled that the school's policies that permitted them to consider a person's race in admission decisions violated the Equal Protection Clause of the 14th Amendment and Title VI, not 7, Title VI of the Civil Rights Act. So Harvard contended that its policy used race as a factor to consider a holistic assessment. It claimed that the policy was intended to ensure minority representation at the school was consistent with minority representation of the population in the area. The race-based action by a government is quote, inherently suspect. And that's the sort of constitutional analysis that's used when themes like race are used as a basis for making a decision. It's not that it's per se illegal, but it is inherently suspect and it needs to be justified. And it's only permitted in extraordinary cases. So what that meant here was that what's called a strict scrutiny analysis applied. To Harvard, a non-state school, because of Title VI of the Civil Rights Act of 1964. To UNC, a state school, North Carolina was another companion case, the University of North Carolina, because of both Title VI and the 14th Amendment. Again, because it's a state school, the 14th Amendment applies. It's engaging in state action. And what the court found was that both of these schools, the policies that they used to consider race as an affirmative action measure in admissions, failed to survive the scrutiny, even if they were well-intentioned. So the rulings are going to have no immediate impact on the legal standards that govern things like affirmative action in employment, DEI in employment, and I'll talk about why in just a second. But the 14th Amendment, as we just mentioned, doesn't apply to private companies. We'll talk about that, right? And that's pretty easily understood. But this raises a whole lot of confusing issues. The same term, affirmative action, is used in all kinds of contexts. We use it in employment law all the time. If you are a government contractor, if you work for a state entity, you have affirmative action obligations under Executive Order 11246, right? And so, we're familiar with that term through our employment experiences, our labor and employment law experiences, but it doesn't necessarily mean the same thing. Affirmative action in employment doesn't mean to give a group priority in decision making, and that's one of the most critical distinctions. In these cases, students were actually given priority based on their race. They were given priority for admission to the universities based on their race. And the schools attempted to defend that. They admitted that's exactly what they did, and they attempted to defend that because they, had reasons for it, expanding the student population, representative, opportunity, all of the factors that we just talked about. In employment law, affirmative action really has only been used to expand the applicant pool. And so if you look at your affirmative action program, if you're a government contractor, it doesn't tell you that you have to hire anybody. It doesn't tell you that you should hire anybody. In fact, it's pretty careful to make sure that we don't use race as a factor in the decision-making process when it comes to new hires or promotions or anything like that. We were never permitted to make a final employment decision on anything other than merit. And even when affirmative action is required as a part of a government contract, it stops short of saying that we must employ a person because that person is a minority. And so I want to make sure that we understand the distinctions there. This case, affirmative action means priority. Affirmative action in employment means expanding the pool, making the opportunities more open to people who have historically not had consistent representation with other with other ethnicities, with other races, with other genders. Those are the things that are distinguishing between these two sets of cases. But again, as I already mentioned, the problem is it's the same term. Affirmative action is the same term. And in my view, it's kind of a cultural signal. It indicates where the court is probably going with any sort of workplace activity that favors one group of employees over another group of employees. And so we have to pay attention to that. Does it pave a path to extend Title VI to Title VII? Does it scrutinize DEI initiatives that are, seeking to improve minority representation in a workforce, just like these universities are attempting to expand it in the college setting at the student population level? Does it scrutinize these initiatives that, on the basis that they focus on a particular race or a gender or an ethnicity, or, as we've already talked about, or sexual orientation, but not another? That it's focusing on a particular class and category of potential workers, but not the potential workers that have historically been well represented. And so these initiatives could be argued to show bias according to, what I believe the court is signaling here, merely because they exist, right? Not that we've made any particular decisions based on them, but because they exist. So employers need to be prepared to explain why a diversity goal is important to the business purposes of the company. To me, it's not that we are prohibited, or that this is indicating that there's going to be some, outright ban on DEI initiatives or things like that. But I think we might need to go a step farther and, be prepared, have an analysis that we documented for the reasons why the diversity goal is important to our business purposes. And that ought to be easy to do. Businesses are struggling with labor right now. There are populations that are underrepresented in the workforce. For example, I have a manufacturing client that has 1,200 manufacturing workers out on the floor, and only 4 of them are women. They would love to have more women in their workforce because they need the labor. They need skilled labor, and there's no reason why a woman couldn't do the job. So it seeks to expand the opportunities for women through recruitment goals, through outreach, through training. And so we need to be prepared for justifications like that, to expand the workforce, to make sure that we are, number one, committing to inclusion for all, in the same way that we, would for the well-represented population, but that we have a justification for why we need to go beyond. That these DEI initiatives have a business purpose that is legitimate and non-discriminatory and important to the operation of the employer. We need to continue to use legitimate non-discriminatory reasons for all our business decisions, and we've got to make sure that whether it's hiring, promotion, discipline, termination, that whatever the reason is, it's legitimate and non-discriminatory, that we can articulate why we did what we did in a way that race was not a factor, gender was not a factor. We've got to be able to justify those things in that way. And really, I think we just need to stay alert. We need to stay alert to state efforts. There's, been an increase in state governments that are passing laws to prohibit DEI programs in the workplace. That doesn't mean that those are necessarily constitutional themselves, but there's an effort to do that. And we need to, look at our state, what's it doing? What are these laws? What do they do to the things that we are attempting to do with our, DEI programs, our outreach programs, our, hiring models? So we want to pay attention to all that. And then finally, we talked earlier about the concept of jurisdictional expansion. And, again, I've told you probably this is the least interesting decision on the facts, but it relates to where your business might be sued. And I think it's really important. And it was one of the last cases that the Supreme Court decided this term. It was a huge surprise to a lot of lawyers. It's most notable because it was a huge surprise, and especially because it came from this court. Typically we think of conservative courts as very business friendly. And here, the surprise is highlighted by the fact that the majority opinion was mixed with conservatives and liberals, and there wasn't really an ideological divide. It wasn't broken down the way these decisions often are by ideology. So it's pretty inside baseball. I'm not going to deny that for the average person to really understand or care how much this decision, how this decision was reached. But the takeaway in a nutshell is that it expands, in frankly, a terrifying way, the places that a business can be sued. Mallory acknowledges a consent-based rationale for personal jurisdiction for businesses. And what that means, as it stood, a business could only be sued where it was either at home or where it engaged in conduct directly related to the dispute. And I'll give you a real brief personal example. So just last week, we got a case dismissed for one of my clients in Arkansas based on lack of personal jurisdiction. Wasn't an employment case, but the facts kind of make it easy to understand the concept. My client is a manufacturer up in Muscle Shoals. They aren't anywhere else. Their principal place of business is in Alabama. They're incorporated in Delaware. They have absolutely no connection to the state of Arkansas. The incident for which they were sued was a wreck that a freight contractor's truck driver had in Arkansas. And he claimed that my client was negligent in the way that it packaged and loaded freight. And then that caused the tractor trailer to tip over and cause an accident that occurred. Again, the accident itself occurred in Arkansas. But if they did that, which obviously they didn't, but if they did it in Alabama. Whatever happened in Alabama. That's where the conduct occurred that the truck driver claims is negligent. So they are neither at home in Arkansas, nor did any of the conduct occur in Arkansas, thus no personal jurisdiction. And the court agreed with us. This case says that despite that, so despite those things that justified lack of personal jurisdiction, they could be sued in Arkansas if they've registered to do business in Arkansas. And Arkansas state law deems registration in the state to subject a business to suit there. So the implications should be obvious. Now, fortunately, in my case, we had not registered to do business in Arkansas, so it was a moot issue for us. But it could have been under Mallory. Plaintiffs lawyers want to sue you where they're going to have the best chance to win, where they have historically had good juries and good judges, and some jurisdictions are just simply plaintiff friendly. They're notoriously that way. So first, litigation tourism is a real risk. I want us to understand that. Plaintiffs, lawyers look for the places. They tour the states. They find the places where the litigation is most advantageous, and that's where they sue you. The Supreme Court signaled that it's open to the idea that a business consents to be sued in the state if it registers to do business in the state. That's what it's telling us. This is separate from that traditional context-based framework that I just talked about. That's what historically has governed personal jurisdiction. So this is a different thing altogether. You can still be subject to personal jurisdiction for contacts, but you can also consent. And that consent exists when you register in a state, and that state says you can be sued there merely because you registered there. Some states want to make litigation tourists welcome in their state. They want you to be, their position is if you register to do business here, you can be sued. And that's as simple as that. So the court probably will pull back from some of this, and there are some questions about whether or not this outcome violates the Commerce Clause and due process. Those issues weren't raised in this Mallory case. And so there may be some future review of this decision that pulls back based on things like the Commerce Clause and due process for someone who doesn't operate in a particular state, has never done business there. All it's done is register to do business. Can you really, under the concept of due process, be sued in that state? But I wanted to bring this up in particular because a lot of you are multi-facility employers. A lot of you have presence in many states, and so the question is, could it have some significant relevance to you? Pay attention to that, right? Even though I think that the court's going to pull back a little bit, if you have registered in multiple states, is it necessary? What are the laws about personal jurisdiction in that state? Am I going to get sued there merely because I've registered to do business? Do I employ people there? What about remote workers? Do I have people that work remotely in that state? Do my employees travel there to perform work? Do I need forum selection clauses in these contracts with workers that might be in these other states who could potentially sue me there? It's particularly true if you've got a risk of a collective action. If there's a potential that a lot of employees could sue you in a different state using litigation tourism to find the place that's most advantageous. So, we want to think about all those things. That's a really significant possibility. It might not affect all of you, but the ones of you that it does affect, it could be really important. So ask yourself those questions. Look at where you're registered and pay attention, because litigation tourism, the notion that, I don't know if how many of you are from Alabama, but there was a time when Alabama was called Tort Hell when I first started practicing law, and that was because people traveled here to file lawsuits in the southern part of the state, and they were getting massive, just unbelievable verdicts. So, that's a thing that plaintiffs' lawyers do, and it's a real risk. So we want to pay attention to that. All right. So those are all of the cases, and that's it for my part of this morning show. So let me take a look real quick and see if there are any questions. It looks like yeah, so someone asked, do you foresee the extension of the substantial increased costs beyond religious subjects? And I touched on this briefly, but yeah, I do. I think that it is possible, if not likely, that that's where we're headed with all of accommodation analysis, that that the court is using this to expand from de minimis the concept of substantial, as to be part of the fundamental analysis for things like Pregnant Worker Fairness Act or the American with Disabilities Act. I guess what I would tell you is, if you called me and said, this person has requested an accommodation for a disability, here's what they've requested, here's the impact that it's going to have on our business. If you're attempting to justify that with something that is incredibly, like, that would satisfy the de minimis test, it's really the bare minimum, I'm going to push back. I'm going to tell you that I would want you to have a little bit better reason than just, basically, we don't feel like it. We need to be able to justify that. And I would have encouraged this sort of substantial cost analysis in the first place. And usually in these accommodation evaluations, you can, it's either going to be something that's really easy to do and you should probably do it, or it's going to be something that is really either complicated, burdensome, or impossible. So often these accommodations really revolve around leave, and I can't be there. And we know that temporary leave can be an accommodation, but an unpredictable, non-specific leave request is not a reasonable accommodation. So think about it from that context. I would go ahead and evaluate all of my accommodation requests, sort of using this substantial increased cost as the backdrop. That's the way I do it. I got another question that's asked if we can share the recording, and I think we do that already. I believe that this morning's show will be published on our website. So if you don't see it on our website within the next few days, shoot me an email and I'll be glad to get you a copy of it. I think it takes a couple of days to format it and get it ready to share. But for sure, anybody that wants it can have it. Again, I think that there'll probably be a link that you can get it easily from our website. But if not, reach out to us, either to me or to whoever your contact is here, and we'll make sure that we get it to you. All right, those seem to be all of the questions for now. If you had questions that you just didn't get typed in, or that come up, as you're thinking about this over the weekend, feel free to give me a call. Feel free to give your regular lawyer at Burr & Foreman a call. That's what we're here for. We're more than happy to help you work through those questions. But thanks again.